All right. Hello, everyone, and welcome to the latest in our ongoing series of antitrust webinars. I'm Chuck Laughlin, a partner in our antitrust group in Washington, D.C., and a former chief trial counsel for the Federal Trade Commission. Let me just begin with a few housekeeping items. First, this webinar is being recorded. The link to the recording and slides will be distributed via email to all participants. Recordings of past webinars are also available. You can find them on the Hogan Lovells website under the subpage titled Events and Webinars. Second, this webinar will count for one CLE credit. We will announce the CLE code later, and the appropriate forms are available to download in the reminder email that was sent yesterday. We'll also resend the forms after the webinar has concluded. Third, we hope to leave some time at the end for questions. If you want to submit a question, please do so using the Q&A button at the bottom of your screen. So with me today, you can go to the next slide. We have Mei-Lin Wen. Mei-Lin is a partner in our antitrust group in Brussels. She advises on competition issues and procedure in relation to multi-jurisdictional mergers and large-scale complex antitrust cases. We also have Alana Katan. She is counsel in our antitrust group in Washington, D.C. Alana advises clients on merger review, conduct investigations before the U.S. antitrust agencies, and provides counseling on a wide variety of antitrust issues. And then we also have Ashley Ifedike. Ashley is an associate in our antitrust group based in Washington, D.C., and she provides antitrust and regulatory advice to healthcare clients. So our webinar today is called Health Care and Pharmaceuticals, Antitrust Update and Outlook in the US and EU. And antitrust in healthcare is always a hot topic, and so we have a lot to talk about today. And we split our webinar into three sections. We're going to begin by discussing some current merger issues in the healthcare space, then discuss conduct issues, and then finally we'll talk about government enforcement trends. So let's kick things off with current merger issues. And Mei-Lin, I want to start with you because there was a very big development in EU merger law last week. And so what can you tell us about that and how it may affect healthcare and pharmaceutical companies?
Great. Thank you so much, Chuck. Indeed, so there was a very big development in the world of merger control on this side of the Atlantic. We had a judgment come out from the highest court in the EU, that's the Court of Justice, dealing with the question of whether and on what condition or what basis the European Commission can seize jurisdiction over transactions that are below threshold transactions. And for those of you who haven't been following this is really about the below threshold deals that authorities have been expressing over the last few years, perhaps longer than a few years, about deals that they are concerned about, but because they've fallen below threshold, they haven't been able to review. And in the EU, our threshold is purely revenue-based. And so you can imagine a transaction where the target has little or no turnover in Europe, and the deal is then, not reviewed by the European Commission. And if you think specifically about the pharmaceutical sector, then you can have deals where the target has, very important, promising pipeline product coming up, attracting high valuations, but because there are no revenues yet, it wouldn't trigger an EU merger control filing. And so this discussion's been interlinked, of course, with the discussion that we've had previous webinars, but also just generally in the antitrust community on killer acquisitions and innovation theories. So about 3-4 years ago, two things happened. First, the European Commission thought very hard about the so-called enforcement gap. What are they going to do about these below threshold mergers? And instead of revising the thresholds, which would have required, a serious sort of legislative procedure, they said that their way around this was to use what's known as the Article 22 referral system. So what that is that for deals that didn't meet the EU thresholds themselves, they were going to have a situation where national competition authorities could refer a case to the European Commission. Now that power has always been there, and that's not controversial. But the shift in policy at that time was to say that we're going to start accepting transactions that don't meet EU thresholds, but also, that don't even meet the national competition authorities' own thresholds. And the impact of this would therefore be, a situation where the Commission could end up reviewing a case that was not only below threshold in the EU, but also actually not notifiable anywhere else in Europe at national level. The second thing that happened around this time was there was actually the perfect opportunity to employ this approach. There was a large, now very well-known transaction, a US to US deal in the genome sequencing space. The target in that deal had no revenues in the EU, nor anywhere else in the world for that matter. And following a complaint on the deal, the French Competition Authority, despite the fact that the French thresholds were not met, the French Competition Authority made a referral up to the Commission. A number of member states joined into that referral request, and the Commission took the decision to accept jurisdiction. And we all now know that that sort of deal was later blocked. And so that left us in a space where the Commission could review a deal below threshold and where no national authority was looking at that, had jurisdiction to look at the deal. And so for some time as advisors, we were counseling clients and saying, look, despite the fact that the target has no revenues in the EU whatsoever, we still can't exclude the situation of a European Commission call-in following this Article 22 referral process. So what's happened is that the parties in that deal that I mentioned earlier took the case to court. They lost at first instance. They appealed that judgment. And last week, on September the 3rd, we have a judgment from the highest court in the EU rejecting the Commission's approach under Article 22. Next slide, please. And the court said, very simply, that the Commission is just not authorized to use the referral system in this way. So it's a limit to how the referral system can be used. The Commission can't accept referrals from national authorities who themselves don't have jurisdiction in the first place. So it's obviously a significant judgment. And I think if we think about where that leaves us on below threshold deals in Europe, first, if a transaction meets a European EU-wide threshold, then the deal needs to be notified to the European Commission. That's unchanged. There is the referral mechanism, but the limit that the court has placed is very clearly now, looking at the law, the Commission does not have the right to accept jurisdiction unless a national authority has jurisdiction. And the way I think of that is that there now always needs to be an anchor jurisdiction at member state level to make a referral upwards to the European Commission. There's been a lot of comment on the case, obviously, and certainly a lot of excitement here in Brussels, but there are still two important points, I think. First, a number of EU member states themselves, and Italy's an example of this, has recently gone through the legislative process to amend their thresholds, and then they now have their own call-in powers. So we're not talking about European Commission level anymore, but EU member state level. A number of them have call-in powers themselves. And so query in light of this judgment and the way the Article 22 system works, the interaction between a call-in on a merger deal at national level, which is then referred up to the European Commission. And the other sort of point is that even absent merger control, and the court was very keen to stress this in the recent judgment, even absent merger control, other antitrust tools can be used to assess transactions, and that includes sort of our abuse of dominance framework. So I think the takeaway here from the EU side is the court has placed an important limit on the interpretation of the law and how the Commission initially wanted to use Article 22. But at the same time, we're not exactly in the all clear. As I said, there are still sort of national call-in powers. And so companies who are doing deals in Europe still need to think about, whether or not filings are required, even in situations where the target has little or no revenues.
Great. Thanks, Maylin. Very helpful. Now, Ashley, let's turn to the US. What kind of issues are you seeing come up now in healthcare mergers?
Thanks, Chuck. It's been a whirlwind with respect to hospital mergers in the United States this year, but I'm going to focus on the big news of the summer, which was the Novant CHS decision and the potential future of failing or flailing firm arguments. So as a brief background, in 2023, Novant announced that it would acquire two CHS hospitals in North Carolina, Lake Norman Regional Medical Center and Davis Regional Medical Center. Then this January, the FTC sued to block the proposed transaction. And throughout the spring, briefing was conducted, and the parties really tried to defend the transaction by arguing that the hospitals to be acquired were not meaningful competitors to Novant, and that without the transaction, the struggling facilities would continue to decline financially and also competitively. In June, the decision from the district court came out, and the district court denied the FTC's request for preliminary injunction. The court largely agreed with Novant and the rationale that I just laid out, and found that the hospitals did not have convincing prospects for improvement and were in danger of closing, and that the hospitals could be fully eliminated as competitors without the transaction. The FTC ultimately appealed the decision, and the parties decided to abandon the transaction before any appellate briefing was filed. And as a result, this district court decision has been vacated. However, I nonetheless think that the district court's decision may be an indicator of court's potential openness to arguments that hinge on the declining financial status of a firm and its future competitive significance, especially when the firm doesn't actually meet the failing firm standards that are traditionally required. And I think this is maybe different in other industries, but I think particularly in healthcare, the healthcare context, we have particular factors that may make courts more open to these arguments. So I'll briefly go through the traditional failing firm arguments. So a failing firm argument is usually very difficult to meet. There's a high threshold which requires showing that the failing firm is in imminent danger of financial failure. So that could be defaulting on loans, past due debts, inability to obtain capital. It's not just only declining financials or revenue or being in the red for a couple of years. They also have to show that there's no possibility of reorganization, and that no other alternative buyer would have been less detrimental to competition. The FTC and DOJ have been pretty clear in the merger guidelines and statements that they're looking for all of these factors when they're deciding whether a failing firm defense will apply, and they've really narrowed it to the situations where all of them apply and the facts look similar to what we've seen previously in case law. However, in the Novant case, we had an argument that looked similar to a failing firm argument. They're talking about the financial status of the target assets, but it wasn't actually a failing firm defense. Neither the parties argued a failing firm defense, and the court didn't really go through that failing firm analysis that I just walked through. However, the court nonetheless found that the transaction was unlikely to substantially lessen competition because of the commercial realities of the situation. And that was the poor financial condition of the hospitals, and that CHS was not investing in these hospitals. And so that situation would continue. I also want to note that the court didn't discredit CHS's decision not to invest in the hospitals. They didn't discredit the competitive position of the assets because of that. Rather, they viewed it as a business choice that the CHS had to make. And given that the network was limited and there's other large competitors there, it was not necessarily worth CHS's investment. And so the court stepped outside of the failing firm argument, but nonetheless looked at the financial condition of the hospitals and decided that the transaction was unlikely to substantially lessen competition, because without the transaction, these two hospitals may not actually be competitor hospitals to Novant's. And so, as I was alluding to earlier, I think this may also have to do with the unique nature of healthcare. When we're talking about healthcare transactions and the potential for a healthcare facility closing, we're talking about people's lives. We're talking about people's ability to access care in a timely fashion, emergency care, deliver babies, or, see a doctor when they think that something has gone wrong. And I think the court's decision seemed to really really wrestle with the commercial realities of what would happen if the transaction didn't happen. So I think moving forward, especially coming out of COVID, when many hospitals are facing financial challenges due to increased labor costs or supply and infrastructure costs, and mergers and partnerships may be the only viable solution for the hospital's future going forward. I think we may see more of these arguments coming out, and I don't think the FTC or DOJ would necessarily budge. I think they're clear on what they believe is a failing firm argument, and they've said that the weakened competitor argument isn't something that they credit. However, I do think at the stage, if a merger is challenged, courts may be more open, just like the court was here in the Novant case, and I think we may see more of that going forward. I do want to note, though, recently, one of the Novant hospitals, there's news that it will be acquired by another party, and this was one of the hospitals that both the parties in the court believed would close. And so I do think that's a little bit of a complicating factor, and I think the facts will be really important in transactions that may make this argument going forward, really projecting the future viability and competitive significance of those assets will be really important going forward. I think we'll see more of these, just as I said, given the environment that a lot of hospitals are in and what is leading to some of these acquisitions. And so I'm curious to see what happens at the court stage, but I think courts may be more open than the FTC and DOJ in terms of entertaining those arguments and, potentially allowing some mergers go through that the FTC and DOJ wouldn't have allowed, and what wouldn't have been allowed under other cases.
Yep, absolutely agree with that, Ashley. The courts will certainly accept arguments that the FTC will not. Now let's turn from merger issues to conduct issues. And Alana, I want to start with you. One of the big issues that's gotten a lot of attention this year concerns Orange Book listings. Can you explain what's going on there?
Thanks, Chuck. So Orange Book patent listings have been really a hot topic in antitrust probably since September of last year, when the FTC issued a policy statement targeting what it views as, quote, improper Orange Book listings by brand manufacturers. Before getting into the recent enforcement updates and the implications, I'll talk just briefly about the concerns underlying the FTC's approach. So the FTC's enforcement efforts are driven by this concern that companies are listing patents in the Orange Book that don't belong in the Orange Book, and that these allegedly improper listings delay or block lower cost generic competition because of that automatic 30-month stay of approval under Hatch-Waxman when a brand manufacturer sues a generic company that made that paragraph 4 certification for infringement. And that occurs regardless of whether the patent is valid or the scope of the patent, or whether the patent should even be listed in the Orange Book. So the FTC's view appears to be that allegedly improperly listed patents can cause substantial harm to consumers, even in the absence of a 30-month stay, because they can distort these competitive incentives and can deter companies from ever developing generics. And they're thereby depriving the market of access to these more affordable medications. And the FTC's view seems to be that it doesn't need to show actual harm to competition when it brings a claim under Section 5 of the FTC Act. In other words, the FTC has effectively been asserting that the improper listing of a patent in the Orange Book is per se illegal under Section 5 of the FTC Act, meaning that the improper listing itself, even in the absence of that 30-month stay, is unlawful. And this means that the FTC considers it doesn't have to show any Orange Book listing actually caused any delay, or that any generic was actually discouraged or incentivized not to enter. It's going to be interesting to see how courts treat an FTC lawsuit under Section 5 of the FTC Act. Because if the FTC were to bring a suit under Section 5, where there hasn't been a stay that was triggered, it would certainly be a test of the FTC's standalone Section 5 authority, meaning the authority to enforce Section 5 of the FTC Act for conduct that does not violate the other antitrust laws. And there's an important question of how courts are going to treat that sort of case? Are they going to agree? And it's also going to be interesting to see whether courts agree that the mere act of listing a supposedly improper patent in the Orange Book is per se unlawful under Section 5, and that no harm to competition needs to be shown. Because per se treatment is really reserved for really serious violations of the antitrust laws, where courts have had significant experience with the conduct, and conduct that is found to always, it's things like price fixing, and bid rigging, where the conduct always harms competition. Are courts going to agree that Orange Book patent listings fall into that bucket? It's not obvious that courts are going to agree it's a per se offense, meaning that it is always anti-competitive, because there are clear policy reasons for listing patents in the Orange Book, such as providing this transparency to generics. But these and other questions will be something that courts have to grapple with if the FTC chooses to litigate an allegedly improper patent listing itself in the absence of any allegation of potential delay through a 30-month stay. Turning to the enforcement efforts, since the FTC policy statement, the FTC has undertaken a flurry of enforcement efforts in at least 3 ways. First, the FTC has sent out 2 rounds of warning letters, each time to 10 pharmaceutical companies, but really 8 given corporate ownership, notifying the companies that the FTC was challenging their patent listings in the Orange Book through the FDA's delisting process. And in each case, these were patents that were directed to the device portions of drug-device combination products. And the FTC views the listings of these device patents as improper because the agency considers that patents that only claim the device without the drug do not meet the listing requirements for the Orange Book. So in response, certain companies removed their patent listings the FTC identified from the Orange Book. Others removed some of their patent listings, but not all. And some companies held firm and maintained all of their listings in the Orange Book. Second, the FTC has also recently filed an amicus brief in private litigation involving asthma inhalers. In that case, the FTC argued that the pharmaceutical company had improperly listed patents in the Orange Book and urged the court to order the patents be delisted. In June of this year, the district court ordered the company to delist 5 patents from the Orange Book, but the company is appealing that ruling to the Federal Circuit, and argument is scheduled for later this year. In that case, importantly, there was a 30-month stay had been triggered. And finally, it was reported in early July of this year that the FTC opened an investigation into a pharmaceutical company because it had refused to remove certain inhaler listing patents from the Orange Book. In terms of the implications, the Orange Book is likely to stay a red-hot topic for the FTC for at least the foreseeable future. The FDA has stated it's working on issuing new guidance about what patents to list in the Orange Book, and that it intends to publish that new guidance later this year. To the extent the FDA does come out with new guidance, it may have an impact on the extent to which the FTC continues to target Orange Book listings or the types of patent listings it decides to target. And finally, the Orange Book is likely to also stay or to become a hot topic in private litigation, especially with this recent district court decision ordering a pharmaceutical company to remove its patents from the Orange Book. We're likely to see even more private cases going forward.
All right, thanks, Alana. So Maylin, let me turn back to you. And can you tell us what the current conduct issues in the EU are that our audience should know about?
Sure, thank you. And there are many, but the one that I want to focus on, and I think I sort of find very interesting, and I think this ties in a little bit to what Elena was saying. The word improper sort of sticks in my mind, but let me tell you what it is. There's just a growing body or movement from the authority side building up cases on the idea of competitor denigration. And what this is sort of spreading false or misleading claims about a competitor's product to basically drive patients and prescribers towards your own product. And in my mind, this has features of sort of false advertising, consumer protection, but then coupled with an abuse of dominance, framework under the antitrust rules. And this isn't a particularly new area of law, but it's evolving, and we've just seen the first case on this at the EU level with the European Commission. And really the pioneers of bringing these cases have been the national competition authorities. So the French competition authority has been particularly active in competitor denigration or disparagement cases. But it's not only the French authority, the Belgian competition authority, the Danish competition authority has looked at this. The UK competition authority is currently looking at this, and the Greek competition authority is also currently looking at this. And some of the conduct that's being explored, I find very interesting. It's sort of launching campaigns relating to substitution warnings between drugs, using a generic versus, the drug that's already on the market. Feeding negative stories about a competitor in the press is something that's been looked at, or the use of communication agencies to make sure that the activities on the communication campaign isn't actually traced back to the company, and that was sort of seen as being particularly manipulative, or sending out alarmist communications to prescribers, for example, to raise doubts on safety. I mentioned that at EU level, we've had our first case. So this is a case that's just closed over the summer. And this is in the iron treatment area. The case started in 2022. And the commission said that for many years, this pharmaceutical company was disparaging basically its closest competitor by spreading misleading information about safety. And these communications were sort of aimed at healthcare professionals, and the strategy was essentially to just stop competition in favor of obviously the company's own blockbuster medication. The case is closed, but the commission didn't actually impose fines. So this case was closed by way of commitments. And that's very interesting because the commission's put into place a 10-year commitments deal with the company, where the company's promised to do things like launch another communication campaign to rectify and undo some of the messaging that's already been sent out. It's also committed, for example, not to make any communication about its competitors that's not based on, what's in the product label, or not based on actual sort of trials that have put, the two products head to head in the first place. And I think while it's interesting to see how the European Commission has dealt with this first case by way of commitments, what we don't have, of course, is then, a decision from the Commission in a way that sort of sets out the guardrails for, companies to think about in terms of what they can and they can't do from a competitor denigration perspective. So I think it's sort of watch this space. There is, of course, another case that's coming up, and we would expect sort of a decision from the European Commission very soon on that. That's in the multiple sclerosis area. In this case, however, the competitor denigration side isn't, a standalone part of the conduct. There was also sort of a discussion on whether there was a patenting abuse there as well. But it would be interesting when the decision comes out to see what the commission says in terms of what's legal and what's not legal for talking about your competitors. So I think for the moment, the takeaways are, companies need to think twice on sort of issuing statements or communication campaigns that are focused on your competitors' products. And I think the caution applies even though we're talking about safety concerns or regulatory warnings that need to be made. I think the reason for engaging in the communications needs to be very clearly about, genuine sort of concerns for patient safety, as opposed to anything that's, going to be perceived to be competition outside the merits, certainly not part of any wider strategy to sort of prevent, a competitor from entering the market. And I think sort of regardless of dominance, we've seen authorities look at competitor denigration from the lens of collusion and collusive behavior as well. So if you're not dominant, then certainly, it's something to be mindful of in terms of cooperation with a competitor to then denigrate a third party's product. That would also sort of be very dangerous. But I think that's a hugely interesting area in the EU space right now, and it's one I'm watching.
Great. Thanks, May-Lin. Ashley, let's come back to you now. And one of the things that's gotten a lot of attention from the FTC lately has been private equity investments in healthcare. What can you tell us about that?
Yes, Chuck, there's definitely been a focus on private equity in healthcare in the United States and the effects of those investments on competition. However, there's a focus more broadly on healthcare ownership by corporate entities and the effect of that. So I will say this is not just the FTC, which generally tends to look at and investigate provider deals and provider conduct. It's been a whole of the government approach is what they're calling it, and it has a coordination of various agencies from the FTC, DOJ to HHS, which is the United States Department of Health and Human Services. So some recent examples demonstrating this focus on private equity and corporate ownership in healthcare and the effects of it include the RFI that the three agencies issued this March. The RFI sought information about the effect of consolidation in healthcare markets, and they're really focusing on private equity funds, investments by other asset managers, and then investments or acquisitions by health systems and private payers. On the same day that this RFI was issued, the FTC actually held a workshop regarding private equity in healthcare. And in that workshop, again, they were talking about the effects of private equity ownership on healthcare assets. And I think it's interesting that the agencies, given that it's not just the FTC and DOJ, are looking beyond effects on competition. They're looking at staffing, they're looking at quality of care, they're looking at use of government funds, especially with the different value-based payment programs. And so in this workshop and even in the comments solicited from the RFI, it's more than just effect on competition. And then in May, the DOJ launched a new task force that's actually focused specifically on healthcare. The task force is called the Healthcare Monopolies and Collusion Task Force, HCMC. And this task force will focus on shaping DOJ's enforcement policy and priorities in healthcare moving forward. And I think the three areas that the DOJ has outlined with this task force is mergers, labor issues, and use of data, which is something that is popping up alongside quality and staffing issues repeatedly in a lot of these comments and discussions that the agencies are holding around private equity and corporate ownership in healthcare. The government also launched a portal for public comments to receive more information and not just limited to the period of the RFI. And they're continuing to receive complaints, and they will look at these complaints and comments and use them to shape their enforcement priorities and policies. And then I want to say that the government's not just in the collecting information phase. They are acting on these enforcement priorities. So that we know that they're investigating vertical integration in healthcare. And then last fall, the FTC filed suit against a healthcare provider and its private equity sponsor for alleged anti-competitive activities. And although the court dismissed the case in relation to the private equity sponsor, it shows that the agency is taking various actions to target these actors, again, private equity and other corporate owners. So I think as parties go forward, especially private equity firms and corporate owners, whether it's hospital systems, private payers, they should be aware that the FTC, DOJ, and HHS are looking at these agencies, and they're not only looking at mergers and acquisitions, but they're looking at day-to-day conduct and operations and staffing and challenges that consumers can and will talk about and submit in this portal. And so I think for these parties going forward, I think they just need to be more aware that, there is, in some sense, a target on their back.
Great. Thanks, Ashley. And Alana, let me turn back to you. We've seen a lot of attention from the FTC on PBMs this year. What can you tell us about that?
Thanks, Chuck. Yep, you're right. The FTC has been heavily focused on really intermediaries in the pharmaceutical supply chain. To date, it's primarily been with respect to PBMs, but GPOs and drug wholesalers have also recently come into the FTC's focus. First, with respect to PBMs, the big action really is the highly publicized 6B study into pharmacy benefit managers. In July of this year, the FTC issued an interim report in the 6B study into PBMs. That interim report is the result of it's the initial result of the 6B study. The FTC announced in June 2022. In terms of key takeaways, first, it's unusual for the FTC to issue an interim report, and the interim report itself appeared to be largely information that FTC was already aware of. The report itself was based on what seemed to be a lot of anecdotal comments from pharmacies, as well as publicly available comments, and less on what the PBM's documents showed they were doing. So it appeared to be a pretty one-sided report, at least this interim report was. Part of the issue is that the FTC is still conducting the 6B study and has noted that it's having difficulty with PBMs allegedly not timely complying with its request. So there is still an open question about when the final report will be ready and whether it will be meaningfully different from the interim report. Second, FTC identified a number of areas of concern that it considers to stem from concentration and vertical integration in the PBM space, including steering of prescriptions to affiliated pharmacies, complex and opaque contract terms with independent pharmacies, and exclusionary rebates, meaning rebates that exclude lower costs such as generic competitors. Finally, in terms of potential areas of rulemaking or policymaking, the only area explicitly identified as an area in the report was around exclusionary rebates, which was interesting because that was the only area explicitly identified for rulemaking or policymaking, because so much of the focus in the report was on the PBM's dealings with pharmacies and steering to affiliated pharmacies. Much less of the report was actually on these rebate practices. However, it's still only an interim report, so the final report may identify further areas. For example, lack of transparency in terms of the contracting terms with independent pharmacies was referenced a few times in the report as well as a concern. And that seems to be an area that the FTC is also focused on contemplating a potential rule or policy, but they didn't call it out as such. So that's where we are in PBMs. Turning next to GPOs and drug wholesalers. GPOs and drug wholesalers have, for the most part, escaped a lot of the scrutiny that the rest of the pharmaceutical supply chain has been under for several years, but that's changed. In February, the FTC and HHS issued a joint request for information seeking public comment on the potential impact of the practices of GPOs and drug wholesalers on generic drug shortages. The FTC raised concerns in the announcement about shortages of generic drugs and whether certain conduct by GPOs and drug wholesalers were contributing to those shortages. The FTC's chair, Lina Khan, announced that the RFI was seeking information on the factors driving shortages and also, quote, scrutinizes the practices of opaque drug middlemen, end quote. The RFI itself is relatively wide-ranging and, according to the FTC, designed to help uncover the causes of and potential solutions to drug shortages. The focuses primarily seem to be on market concentration of GPOs and drug wholesalers and of contracting practices, but a huge variety of topics included in its scope. And given that wide range of topics in the RFI, it really does look like the FTC and HHS are on a bit of a fishing trip to see what they can find on GPOs and drug wholesalers that may relate to these drug shortages. So it remains to be seen what, if anything, will come out of this RFI process, but it's safe to say that, like PBMs, which have been in the FTC's crosshairs for quite a while now and will continue to be, GPOs and drug wholesalers are now also in the FTC's focus.
Great. Thanks, Alana. And I actually want to stick with you for a minute because before we move on from conduct issues, it's very hard to talk about a webinar on antitrust issues in the pharmaceutical space without at least mentioning the so-called generic delay issues that have been such a big topic for the last 25 years or so. And so, Alana, what can you tell us about the developments in product hopping cases in particular?
Next slide, please. Thank you. This year, there have been at least 2 motions to dismiss that have been decided in cases involving product hopping allegations. While it's still a relatively nascent area of litigation, courts have largely aligned on the rule that so-called hard switches are illegal and soft switches are not. Although the definitions really do vary to a degree, In a hard switch, the brand manufacturer is actually withdrawing the original formulation from the market, or it's discontinuing the drug, or it announces the withdrawal or discontinuation of that original drug. And it's typically on the eve of patent expiration for the original drug. Courts have viewed that as coercive, effectively forcing patients to take the new version, and therefore found that unlawful. In a soft switch, there's no withdrawal or discontinuance or announcement of withdrawal or discontinuance, but a new version of a drug is introduced and the existing drug is still on the market prior to generic entry. And the brand manufacturer is taking various steps to persuade the market to move over to the new drug on which it has patent protection. And that's generally been viewed as lawful, but the cases are really fact specific. And a recent case allowed product hop claims to go forward, even in the absence of a hard switch, where the product hop was alleged to be part of a broader anti-competitive scheme to monopolize. The challenge, or one of the challenges really is that these so-called schemes involving product hops may involve very different buckets of conduct by different parts of the company that all occur around the same time. And although each type of conduct in the scheme may be legal if you look at it in isolation, together there's the concern that the conduct is coercing the market to switch to the new formulation of a drug that doesn't have generic competition. And that means that companies really do need to consider the full extent of what they're doing around lifecycle management when they're assessing antitrust risk, because different parts of the scheme, such as discussions with PBMs on formulary placement or marketing to physicians and pharmacies, that may be undertaken by entirely different employees and teams within the company. At the end of the day, no product hopping case has yet made it to trial, and the cases still seem to be very fact dependent and, to an extent, not entirely consistent. So it does remain to be seen how product hopping cases would be regarded if and when they make it to trial, but really an important area for companies to focus on, including in their compliance program.
Great. Thanks, Alana. Let's now turn to our last topic, which is government enforcement trends in healthcare. And May-Lin, I'm going to start with you. What should our audience know about government enforcement in the EU?
Right. So early on this year, the European Commission published its report on enforcement, and that covered a 5-year period from 2018 to 2022, building upon a previous report that they did for a longer period of time. The report actually looks at enforcement in Europe, so by the European Commission as well as by the national competition authorities. And there are some really important, really interesting takeaways from the report. Enforcement activity in the life sciences space against pharmaceutical companies in particular is definitely on the rise. Fines of more than $850 million were imposed during that period. And really at the forefront of that, again, has been the national member states, with the French Competition Authority alone being responsible for fines of, around $500 million. But it's not just sort of the large fines being imposed by the large, European Commission, EU member states or the European Commission, but also smaller states like Romania and Lithuania, who have been active and they've imposed fines of about 80 million euros each. We also see that abuse of dominance is an absolutely crucial part of the enforcer's toolbox, with abuse of dominance cases accounting for more than 50% of all cases in Europe over this period. And some of the sort of theories of harm that the authorities have gone for are sort of excessive pricing investigations, unfair pricing issues, even vexatious sham litigation, competitor denigration, as I've mentioned, and then as well as abusive pricing and rebates. Of course, Chuck, if you mentioned pay for delay, that's also there and features in there as well, as is sort of cartel conduct in the pharmaceutical sector. So I think some really interesting sort of takeaways from the report looking back at the past, and I think what that means for us, going forward. I think companies are, operating in the EU need to be vigilant, not just at the European Commission level, but also the EU member state national authorities, who show that they're very, very active in this space. Sometimes I think maybe there's a perception even national authorities are often able to take on more cases. They're more nimble. They're taking on the cases, the vertical cases, for example, in relation to distribution arrangement or parallel trade. And they're not shying away from pushing the boundaries on where competition law is in this space either. So I think as a future trend, it's sort of more cooperation between the European Commission and the national competition authorities, with both sides playing a real role in bringing more cases in this sector.
Great. Thanks, Malin. Now, turning back to the U.S., in the U.S., of course, we have both federal and state antitrust enforcement. And Ashley, let me ask you to tell us about some state enforcement trends lately.
Yes, the states are getting more and more involved in healthcare merger enforcement, merger review, as well as enforcement as well, and enforcement against anti-competitive conduct in the healthcare industry. So I think a saying that many people in the healthcare industry are familiar with is that healthcare is local, and antitrust enforcement is another realm in which that is true. For a healthcare transaction, the government is looking at competition in markets as narrow as counties or markets shaped by local geographies, such as highway routes, downtown metropolis. And so you're really looking at a small localized border. Additionally, when parties are talking about the pro-competitive benefits for a healthcare merger, a lot of times they're looking at the effects on the community that those hospitals serve. And so increasing access to care in a specific community, boosting economic activity in that community from investments in new buildings, technology, and jobs. So given this local focus of a lot of healthcare transactions, it's no surprise that we're seeing increased state involvement, including new laws, as well as state participation and investigation alongside federal authorities, and states even undertaking their own separate investigations. So the first trend in state involvement I'll talk about is the new laws that are coming about with respect to the merger review process. At the federal level, a Hart-Scott-Rodino pre-merger notification is typically required for mergers of a certain size. Now, several states are passing their own merger notification or even approval laws that are separate from the Hart-Scott-Rodino requirements and separate from the state laws about certificate of need or charitable trust and nonprofit transactions. So today we see 14 states have healthcare specific merger notification laws, and these laws come in different flavors. Some require the parties just to notify the state agencies, typically the Attorney General or the State Department of Health, of the merger, and that's typically done a specified number of days before. And then if the state wants to investigate further or block the transaction, the state must do so through means in the state law, such as suing to block the merger or issuing some type of civil investigative demand. And so a state that has a law like that is Minnesota. They passed their law May 2023. On the other end, there are some states that require state approval before the merger can close. State that does that is Oregon. So in that state, the merging parties have to submit the notice 180 days before, and then the reviewing authorities will review the transaction, decide whether to approve it with conditions, or disapprove it. Some states in this reviewing process have sought agreements with the parties, and those agreements are pretty localized. They talk about the local factors. So it may be agreement with the parties that they will continue to provide services for a certain number of years. And we've seen that happen. And we've also seen on the enforcement end, states really ensuring that these agreements are followed through. And so most recently, we saw North Carolina sue to enforce the terms of an asset purchase agreement of hospitals for an acquisition closed a couple years ago. And there we see the states continuing to be involved, not only in the reviewing process, but ensuring that those terms are met. We're also seeing states file their own lawsuits in addition to joining with or not just joining with the federal government. And so we've seen Colorado file to block mergers, as well as file to enforce their state antitrust laws with respect to alleged anti-competitive activities. And then we're also seeing states investigate conduct that's outside of mergers. We're seeing them investigate things such as non-competes, non-solicitation provisions, and really focusing on labor and the issues of the people in that community. And so I want to say, like the federal government, the state is building up their capabilities and resources and antitrust in particular, and really looking at the needs of the community, whether it's at the merger level, where they're asking the merging parties to agree to provide certain services, or they're looking at something such as the non-solicits. And so they're building up this expertise, just like the federal government. And I expect them to be more and more involved. And I think it's going to be on the merger side, but also on the conduct side.
Great. Thank you, Ashley. At this point, let's give out our CLE code. So can we skip ahead, I guess, one slide and one more? So the CLE code is fall 2024. Please make a note of that because you're going to need it for your CLE forms, fall 2024. And as a reminder, the forms to submit CLE credit will be emailed to you again after the webinar. Now, Alana, let me jump back to you. And you've talked a lot about the FTC today. And can you tell us what else the FTC has been up to in the healthcare space?
Absolutely. So one of the big things the FTC has been active in this year is its policy rule. Since February of this year, the FTC has submitted 4 comments to other agencies involving the pharmaceutical space, 3 of which relate to pharmaceutical patents specifically, and the last of which relates to biosimilars. These comments, which I'll talk about briefly, together reflect the agency's continued focus on the pharmaceutical industry and a heightened focus on patenting practices and encouraging the entry of lower cost drugs. The first one, in February 2024, the FTC submitted comments to the National Institute of Standards and Technology in response to NIST's draft guidance on margin rights under the Bayh-Dole Act, meaning on NIST's proposed framework on when the federal government should require patent holders to license to third parties patents developed with federal funding. In December of 2023, NIST proposed a broad and flexible guidance framework to help federal agencies assess when it might be appropriate to exercise margin rights. And they made it clear that high price would be a basis for the government to exercise margin rights. The FTC supported NIST's broad and flexible approach to margin rights, including that high prescription drug prices should be a basis for federal agencies to margin on a patent. And practically speaking, the impact of these margin rights may be limited for various reasons. The major one being that pharmaceuticals are typically well protected by numerous patents, and there may be both federally funded patents and non-federally funded patents, which really limits the efficacy of compelling a pharma company to license its federally funded patents to a third party. Second, in June 2024, the FTC submitted comments in response to USPTO's notice of proposed rulemaking regarding proposed changes to the patent trial and appeal board proceedings. And the FTC's comments focused on the proposed new requirement for parties to file with USPTO all pre-institution patent settlement agreements before the PTAB, meaning agreements that are entered into before the PTAB decides to initiate any proceeding or trial. These relate to settlement agreements arising in inter partes review, as well as in post-grant review proceedings. In April, USPTO proposed a rule that would require parties to disclose PTAB settlement agreements as well as collateral agreements, regardless of when those agreements are entered into. And the FTC supported the rule, noting it would help the FTC be able to identify reverse payment settlements or so-called pay-for-delay agreements between pharmaceutical companies, although the proposed rule itself was not limited to the pharmaceutical industry. Third, in July 2024, the FTC submitted comments to the USPTO in response to proposed rules regarding terminal disclaimers. And this is a little bit complicated, but essentially in a very simple terms, in May, USPTO proposed a rule that a patent will be unenforceable if it's connected by one of these terminal disclaimers to another patent in which a claim has been finally held to be unpatentable or invalid by a federal court, or by the USPTO, and there are no appeal rights left. And the proposed rule would effectively require patent applicants who file these terminal disclaimers, which tend to be filed when there are overlapping patent claims, essentially require patent applicants to agree that the invalidity of these overlapping patents would rise and fall together in terms of enforceability. The proposed rule, if enacted, would mean that a potential competitor like a generic entrant would not need to invalidate multiple patents together, because invalidating a claim in the original patent would also mean that a later patent wouldn't be enforceable if it has claims that are tied by that terminal disclaimer to the original patent. And there are quite a few downsides of this rule, including that it could incentivize narrower patent disclosures, which could harm future R&D efforts by pharmaceutical companies, and also that the proposed rule really might have a chilling effect on terminal disclaimers and continuation patents. The FTC, of course, supported the USPTO's rule, raising the concern that today these terminal disclaimers may be used by patent applicants to raise the costs of potential competitors by requiring those competitors who enter to defend against multiple patent infringement claims, even where those patent claims are essentially the same. Fourth, and most recently, in August, the FTC submitted comments supporting the FDA's draft guidance on interchangeable biosimilar drugs, which the draft guidance removed a recommendation for biosimilar applicants to submit certain data in order to demonstrate interchangeability with the reference product. And so in its comments, the FTC raised concerns that today few biosimilars are actually designated as interchangeable with the reference product. And the FTC thinks that this proposed rule will increase the number of products that are interchangeable and hopefully increase competition. The FTC also advocated for the FDA to explain how existing biosimilars can be designated as interchangeable. And the FTC argued that if a brand company tries to advertise that biosimilars are not as effective or safe, that could be misleading or deceptive advertising. Looking at the four comments to other agencies together, there's several takeaways. The first one is the fact that the FTC has submitted 4 comments on pharmaceuticals since February, and 3 of those are on pharmaceutical patents. That reflects the agency's continued focus on pharmaceutical companies and really on pharmaceutical patents in particular. Second is the FTC's comments make it clear that it does view other federal agencies as having a role to play in preventing conduct that the FTC views as anti-competitive, such as in preventing so-called patent thickets from preventing generic entry. And third and finally, the comments suggest we may see new and innovative theories challenging overlapping patents and over-patenting in particular, or even some unfair and deceptive practices claims about biosimilars. We might see those start to be brought. So we're nowhere near the end of the innovative theories the FTC may bring, and we might see some of those theories pop up in private litigation as well.
Great. Thank you, Alana. Very, very comprehensive. It'd be very interesting to see where that goes. We're at just about at the top of the hour, and so we do have a couple of questions, but I don't think we really have time to get into them, unfortunately. I apologize for that. But so let me just thank everyone for joining us. We really appreciate it. We do these webinars quarterly. Our next one will be in December, where we will take a look at the biggest antitrust topics and events of 2024 and discuss what companies can expect in 2025 with respect to antitrust. So please keep a lookout for that announcement, and I hope that you can all enjoy it. Join us then. Thank you.
Thank you.